Good evening. What? What are you doing?
Yes, start again.
Good evening. Since doing 3 videos in the past 2 weeks in relation to misconceived ideas and dishonest statements made by Anne Toomey, I never once attacked her personally, but now she's added a case that I was involved in and tried to make out that we are being instructed by overseas people. Never happened. Don't tell lies about me, Anne Toomey. Don't even suggest I misrepresented anything or I belong to a group of any others. I've studied the Constitution for 50 odd years, a hell of a lot longer than you have. I find what you stated on YouTube, why did you put it on YouTube? Why didn't you put it on Facebook? So we could complain and get you wiped out for lying on Facebook. But you didn't. You lied on YouTube instead, trying to make out that what you're so smart. See this book? This is a red book. You said it's not the Constitution. It's only a little book. And as I said, which was true, not in your racket of making out the lies, read that. Commonwealth Constitution Act 1900 UK. That's in this book, as I said, and it is 6364 Victoria. That is this Constitution, 6364 Victoria. So I didn't tell lies, I didn't mislead. It has 9 clauses, not only relying on clause 9. That's another thing you said previously, which was a lie. Are you a liar? I'm not calling you one. You're repeating lies. Now, this contains the full Constitution. As of the 9th of July 1900, when it was proclaimed by Queen Victoria. So, what I said there was true. What you said there was not true. That it's not the Constitution. Then, as you go past all those things, it goes to the individual sections. Now, look, like 2. That's section 2 in this Act. Section 2. The Governor-General appointed by the Queen shall be Her Majesty's representative in the Commonwealth and shall have and may exercise in the Commonwealth during the Queen's pleasure, but subject to this Constitution, such powers and functions of the Queen as Her Majesty may be pleased to assign to him. You want to make it her? That's a matter for a honest parliament. Well, we haven't got one of those. Now, that shows, then it goes in and explains where it all came from. This is what I said from the books which are over your left shoulder, which you're no longer showing because you went a different part of your library. Now, the reason I'm going here is 5138. I want to explain something to you because you made a lot of statements. 5130, we want 38. (35, 6, 7, 8). The exercise within the Commonwealth at the request or with the concurrence of the parliaments of all the states directly concerned of any power which can, at the establishment of this Constitution, be exercised only by the Parliament of the United Kingdom by the Federal Council. And here in Quick and Garran, and Sir Samuel Griffiths, who you refer to, and he did not say what you said. There is no evidence of that in anything except your little black books, which are not a true record. This actually is. Powers exercisable by the Federal Council. It is equally difficult to give any effect to the power to make laws in respect of the exercise of powers which at the establishment of the Commonwealth were only exercisable by the Federal Council. In the first place, the Federal Council Act is repealed by covering Clause 7 of the Commonwealth Act, which took effect on the passing of the Act on the 9th of July 1900. So there wasn't anything. There wasn't anything. No, and it gets more interesting. So that at the date of the establishment of the Commonwealth, no powers whatsoever are exercisable by the Federal Council. See remarks by Mr. Isaacs and Mr. Barton. Coverage Department, Melbourne, PP 2256. That's in the records you have. That's if they're correct, but they're not. But apart from this question, the powers expressly given to the Federal Parliament seem to include every power which was ever exercisable by the Federal Council. The Federal Council only had independent legislative authority over 7 subjects. See PP 111-2 Supra. Every one of which is covered by Section 51 of this Constitution, and its powers of legislation upon reference by the parliaments of the colonies were certainly no wider and probably narrower than those given to the parliaments of the Commonwealth by subsection 37. Now what that means to you, so that you can clear up all your misgivings in relation to the Constitution and start teaching the truth, it would be advisable to see, is there any authority over land in Section 51 of the Constitution? Is there any authority to tax land in Section 51 of the Constitution? Because the states are created under 107, 108 and 109 and draw their authority referentially from the Constitution. So if there was only 7 legislative areas ever exercisable by Australasian Council, and even less by the colonies, which is what I just stated, and they're all in Section 51 of the Constitution, please explain to the Australian people why you've said what you said and where the states had the authority to have local government. Because I tell you now, and as for it being in the state constitutions, that's an outright lie. And I say it's a lie. This is the state constitution of Western Australia. This is the unlawful one put in place at Federation. Now, you lied because you said every state had the power in their constitution. No, they didn't. That's a lie. So, where is it in here? It's in 52. Local government. 52. 1. The legislature shall maintain a system of local government bodies elected and constituted in such manner as the legislature may from time to time provide. Each elected local governing body shall have such power as the legislature may from time to time provide, being such powers as the legislature considers necessary for the better government of the area in respect of which the body is constituted. Section 52 of this Act does not affect the operation of any law prescribed. So let's look, where did this get added? And number 88 in 1979, as I said. See, this Constitution was put in place at Federation with 32 sections missing. They repealed Section 52 and 53. How do I know that? Because you go to the state constitution, 52 and 53, which is where you said it says, and nowhere in this constitution does it mention local government. So that's a lie. You're either repeating other people's lies or lying yourself. You make up your mind. Who outside this country? Oh, look at the Fabian Society, Freemasons. They're the interfering people from outside this country. Are you suggesting I'm involved in them? Some idiots have, but I'm not. I never have been. 52. The colony shall be divided into 5 electoral divisions, each returning 3 members to serve in the Legislative Council, that is to say, the Metropolitan Division and all those. 53. Every man shall be entitled to be registered as a voter. So it doesn't say what you said it did. So this one is fraudulent. This is the correct one. And look at that. An act to confer a constitution on Western Australia and to grant a civil list to Her Majesty. Reserved 29th of April 1889. Royal Assent proclaimed 21st of October 1890. So then you have a bigger problem. And it's all coming out in your lies. The lies you keep repeating and won't listen to. Let's look at the referendum, 1974. You said it was just to allow the federal parliament to pay money direct to the local government. Yes, that's correct. But what it would have done if we had have approved that is gain authority for local government to exist in the first time, because it wasn't in our state constitution. I just read it. It wasn't there. It's still not there because the constitution used is unlawful. What have you got to say about that, Anne Toomey? Are you going to answer with the truth, or are you going to continue putting forward lies? And that's all it is. It's a lie. It's not the truth. It's a lie. Now, let's fast forward to 1988. What happened in 1988? It was to add 119A to recognise local government. How? By answering 4 questions. Do you approve the continuance of local government? We said no. Clear. Do you approve the establishment of local government? We said no. Clear. What have you got to say about that? Do you approve the empowering of local government? We said no. The Constitution is clear. Supreme, absolute and uncontrollable authority remains where? With the people. 128 says both houses of Parliament must put the legislation together. Must approve it, not put it together. Go to chapter 1. Who puts legislation together? Anne Toomey, constitutional expert, purported. I say purported because your statements negate the fact that you even know anything about the Constitution. Oh, I know this, I teach this, you teach crap. Nonsense and lies. I'm saying it because I'm the Glew from Glew versus the Greenwich Shire, and I'm coming to that in a minute because you lied about that. Because you went on the attack against me. That was a silly thing to do. Because when you get in my face, I'll get in yours. You want to sue me in court? Take me to court. I'll prove it. I have the transcripts of what I put to that liar, those 3 liars that sat in that court. Go read Forge versus ASIC, the cable decision in the High Court. You talk about courts. I'm not interested in one judge or Edelman the moron in the High Court sitting as a single judge in direct contravention of habeas corpus. And he sat on that. Edelman and I, well, he doesn't know me, but I know him and his antics when I was in the police force. He even answered one of my applications to the High Court himself. In direct contravention of habeas corpus, says no single judge can sit in judgment of anybody, nor can they. No parliament can change that. And as for states having plenary power, how do they have plenary power? Well, their power after establishment of the state, because they didn't exist before federation, don't say they did, which is what Wheeler, Paul and Bus put to the High Court, to me, and I put to the High Court, sorry, let's correct that. The states did not. They were colonies who ceased to exist on the proclamation of the Constitution under the provisions of Clause 7. You only say there's only one clause that establishes the Commonwealth, and that's Clause 9. Well, you're wrong. Clause 4 does, and 9. And 1, 2, 3, 4, 5, 6, 7, 8, 9 establishes the Commonwealth. So you lied about that. That is a lie that you told. You studied the Constitution. How can you turn around and say that it's not the case, what I've just said? The 9 clauses are part of the Commonwealth Constitution Act. That is an enabling act. It states that. Where does it state it? In the front of the red book that you deny is the Constitution. Of course it's the Constitution. It contains that. Commonwealth Constitution Act 1900 UK, and each section, and then explains what it means. Look at that. The framers explained it, including Sir Isaac, or Sir Samuel Griffiths, and the other people that you want to bring up. So you misled. So when a referendum fails, it just doesn't carry or not carry. That's a lie. It's either approved by the people with a yes vote, or it's denied by the people was a no vote. They said no to the continuance, no to the establishment, no to the empowering, and no to any other ability they got. So you lied. Why don't you tell the truth? Because the text you got. You see, before I started teaching on Facebook, and I am teaching, I was awarded the OWB for research in the common law heritage of this country and the Constitution. Why? Because I took the time to study it and somebody recognised it and they gave me an award. But who I'm not interested in the award. This is not about accolades. You can sit there and pronounce yourself Mrs. Expert, Miss Expert, whatever you are, but prove it. Because I've read the law. I've read all the acts and statutes. A judge's statement, when incorrect, is nothing but nonsense. And none of them are signed. None of them are signed. You understand that? Mary Galdron in the Supreme Court of New South Wales said an unsigned document has the same value as toilet paper. I disagree. It's even worse because simply it would scratch you. You don't like me, you don't like what I'm saying, but let's go to Glew versus the Greenwich Shire. What was in the submissions to the court? And I asked so-called Justice Wheeler, who was a quorum. By the way, a quorum is an unelected judge, a person impersonating a judge who isn't one. Comprehend that? Do you understand that? Comprehend it? You know what that means? Do you know what truth means? Then start telling it. Wheeler come out with the biggest load of crap I've ever heard. I asked her, had she read my submission? She said yes, and we'll deal with them individually. She lied. Because in there were 9 or 10 decisions of the High Court, and she ignored them. That is criminal contempt of the High Court. She ignored them. HCA 48 in 1996 said her decision is an outright lie, backed up by Pullen and Buss. Did. Read the transcript. You see, these maggot lawyers that call themselves state solicitors that have not officers of the Crown, so they're treasonous scum sitting in our business, in our public sector, when they should be Crown officers and they're not, nor are our judges. How do I know that? I'll come to that one in a minute. This will open your eyes to some truth if you really want to hear it, but I doubt it. You're still too busy promoting yourself on YouTube. Well, you failed this time, lady. Go back to HCA 48. That's when James McGinty, the purported Attorney General of Western Australia, hadn't done all his paperwork and was chastised by the High Court for not doing it. So don't come back before us until you finish all your paperwork. That's what he was told. Then, on paragraph 17 of that decision, he was told that 106 allows the state constitutions to continue subject to the Commonwealth Constitution. So even if you're right about the red book, go read the Commonwealth Constitution. 106 allows it. Sir Samuel Griffiths, who you brought up, in HCA 39 of 1915, stated, here we find 106 binds the state constitution and all laws made pursuant to it to the overriding authority of the Commonwealth Constitution. So if what I said is correct and this is the Constitution and the local government was not in it and it wasn't, you got that wrong. You got that wrong. So it's a lie. Either put there by you or put by others to you and you're pronouncing it and never bother to check it out. So now you've got a problem. There is no local government in the Commonwealth Constitution. It can continue subject to this Constitution. It can only allow the Constitution to continue and all laws made pursuant to it to the overriding authority of the Commonwealth Constitution. And if it's not in the Commonwealth Constitution, it's reserved to the states or remains with the people. We were asked in 1988, we said no. No means no, so you can't have it. So is it lawful to have local government? No. New South Wales you quoted from, that's nice. Which one? Which one? Have you done your homework? Let's see if you've done this homework. And to me, in August 1902, New South Wales removed its entire state constitution, threw it in the bin, therefore failing to comply with 106. Don't say it did. Did it have the power to throw the constitution in the bin? No. It was made letters patent on the 29th of October 1900, like Western Australia's, New South Wales, Queensland, Victoria, Tasmania and South Australia. They were all made letters patent on the 29th of October 1900. And if you know what you're talking about, you'd know the statute of monopolies prohibits you changing, altering or any way interfering in a letters patent without the express permission of the reigning monarch. And you didn't get it. You didn't get it. Your explanation of the Queen signing the Australia Act was just as big a load of nonsense. I've read what took place then, it wasn't that. That's a lie. But let's go back to the local government. Queensland removed its upper house. Where then does that Queensland Parliament comply with the Commonwealth Constitution in accordance with 107, 108 and 109? It doesn't. So that constitution's gone and the state with it. 1934, South Australia dumped its constitution, replaced it with another one. Did it bring local government forward in that? No. Is it in there now? No. It is after 1979. Now, Tasmania did the same. 1975, Victoria did the same. Dumped its entire constitution, which is butchered anyway, but it doesn't matter. Now, read the Constitution. You read it. I have. We needed 6 states to create the first federal parliament. Western Australia was out of the question. Not because it was running late going in, because it didn't, because this is a fraudulent constitution. And this is the correct one. What part of that don't you understand? The lot. The lot. So let's continue on. Queensland removed its upper house. That's gone. As they took each constitution out, each state come out, where did they get the representatives of each state to create the first federal parliament? Quick and Garron said they didn't have the power, and they were correct. In accordance with the provisions of Clause 7, that was correct. But where you let down, and with your dishonest twist on every part of the Constitution, Antomy, you're going to have to clean it up and go back and sort out the truth, because you're certainly not telling it. You're certainly not. You can attack me. I don't care. I don't care. You come and attack me. I'll come back in your face, because when you lie about me, I'll tell the truth about you. You understand that? I'm not going away. I've said this plenty of times before. I was given this job to do. I'm doing it. I'm going to bring you down, and it's not from a foreign power. And when you find out, you understand you cannot defeat the person who gave me this job. Now, understand this. There is no lawful states in this country. We have no lawful federal parliament. So how do you run local government when none of those exist? Yep. No one's ever proved local government doesn't exist in the court. I did in 1919, to the extent the magistrate got out and ran out of the court when, after telling the council he couldn't give them authority to remove my property off my land. He couldn't give them authority to take the land. Go to Magna Carta 39. I had to have a lawful judgment on my peers, but they wouldn't do it because they had to deal with this. The fraudulent use of the state constitution of Western Australia, which rejected and broke up the fact that there was no 6 states to create, whose representatives created the federal parliament. Now, it's amazing, the Christian lobby in Western Australia said, we got a chance to do something, because Western Australia has packed deaths, crapped themselves, whichever way you want to put it, and now suddenly has decided, well, that everyone who's voted into Parliament represents the whole state. Well, Chapter 1 of the Constitution states that. Why didn't you pick up on that? Why aren't you teaching that? Why aren't you teaching it? Because you don't know. And the states did not have plenary power. When they are granted a power in a certain area, they have plenary power in relation to that actual section of power. But because none of them have their constitutions, none of them have any power. You can't work it out. That's not my problem. You see, when with HCA 48 and 1996, that was in front of Wheeler, Pullman Bus, and they lied. And if you got the transcript, you'll see that I handed up 3 documents to the 3 judges. They said, "What are these?" I said, "Would you like to read them?" And they looked at them. I said, "They're warrants for your arrest to appear before the Supreme Court of Victoria to stand trial for treason, because none of them has sworn the lawful oath." Now, Cable decision, as I said, lays out the fact that the Supreme Court judges in every state must meet the constitutional requirements. Do they? No. Forge versus Asset. Not only permanent judges, but temporary judges must swear the oath of allegiance contained in our Constitution. Do they? No. How do I know this? On the 21st of June 2011, I asked Wayne Stewart Martin, the purported Chief Justice of the Supreme Court, who sat alone and refused to give me a trial by jury and lied because he said he could change patents and make claims against patents. He made claims that all my patents were of the same invention. What an absolute moron. They have to be new and novel. But take that aside. I said to him, "Have you sworn the oath contained in the Constitution?" He said, "No." I said, "Why not?" He said, "Because I don't have to." I don't have to. 1 William and Mary says, every public servant, everybody who takes a position of authority in this country or anywhere in the British Empire, before taking that authority, must swear the oath to the Crown. Must. Requirement. Forge versus Essex says not only permanent judges but temporary judges must swear the oath before taking their position. 42 of the Constitution says every senator and every member of the House of Representatives, before taking their seat, must swear the oath contained in the Constitution. You know what, Anne Toomey? I'm going back to court because those morons, as I explained, that work for the public service calling themselves state solicitors, served document on me. You know what the document was? It was an affidavit contained every single one of my cases, all stacked up neatly as one document. Those fools still haven't realised I filed it back. I put an affidavit over it and filed it back as my affidavit in defence. And Craig William Sanderson, in direct criminal contempt of the High Court of Australia, ruled that, look at that, when I wasn't even in the court, that I was vexatious. All I did is challenge his jurisdiction, which is my right under the Constitution, to challenge his jurisdiction under the Judiciary Act before he hands down the decision. He never got it to hand it down. I challenged his right to sit there under Harris versus Caledine and 7 other decisions of the High Court. So he sat in criminal contempt of the High Court. And when it was brought up in the Kalgoorlie Court, the judge sat there and just looked at me and looked at the solicitor, because the solicitor proved he was a liar and a fraud. I went in the witness box. The first thing the solicitor says, "When you were sacked out of the police force." Well, sorry, you haven't got that choice, because I held up my retired police officer's ID, said I was boarded out medically unfit, so he lied about that. Then the judge said, "Have you got another question?" He said, "Yes, when you were declared vexatious." I said, "Wasn't declared vexatious." He said, "Yes, you were." I said, "No." Sanderson spat the dummy, and the transcript says he jumped up and down in his seat, waved his arms and yelled out, "Nonsense, nonsense." He didn't yell that out. Nonsense isn't spelt with an F and a C. And he used that language in the court, in the Supreme Court of Western Australia, like a mongrel dog that he is. And that's all he is. He has no authority to pass a judicial function. And you stick up for these people, you and Toomey are teaching that these people have some kind of authority, but they have none. His sitting in the court was in criminal contempt of the High Court. He said they couldn't sit, and I read it to him, and that's what he chucked a wobbly at me for. He chucked a wobbly at me because of that, and started yelling, and he had me evicted from the court. He went back in the afternoon and declared me vexatious when I wasn't there. The Constitution, 51 subsection 24, says no man can be held to a decision of a court given in his absence or without his ability to defend himself. What do you say about that, Toomey? Oh, that's not the Constitution. Yes, it is. Yes, it is. It's called justice. You can't even see that. You want to attack me? Why don't you bring up some more cases? And you brought up the one in the High Court. You're talking about the decision handed down by the registrar, claiming to be under the instruction of 2 judges, not 1, in relation to Glew versus the Greenwich Shire. They weren't signed, so they weren't decisions, and they were quorums. I've got the documents, said so. I've got those documents. I brought it up in the Magistrates Court in Geraldton in 2019 and showed him, because he tried the same crap that you tried, because that's what you're teaching. And you're teaching these people that what you're saying is true when it's not. It's not. You see, if a judge doesn't sign, who the hell made that decision? He's a quorum, not even a judge. Has he sworn the oath of allegiance? No. Has he selected by the Governor General and Council? No. What's he doing in the court? Where's your problem? You see, you're about to find out some things are happening in this country you don't know anything about, and you're incapable of teaching people anything from now on because you're attainted to treason. What you said is treason. Blatant treason. No state. The state has the power to set up municipal instruments. That's line 8 on 936. You comprehend that? Municipal institutions and local government. The state has the authority. The people of the states. The people of the states. Supreme, absolute and uncontrollable authority remains with the people. We have the say. We were asked, we said no, but let's not worry too much about that, because that's just the truth. Isn't it, Toomey? Or you want to go and get your jollies off going, oh, I know this. You know nothing until you sit down and you study if those books that you had over your left shoulder in the other one that video that I referred to, if you bothered to take the time to read those, and if they confer with what Quick and Garron wrote in there, that's Dr. Sir John Quick and Sir Robert Garron. Very, very highly sought after, highly respected barristers who sat along with Isaacs, Sir Samuel Griffiths, Parkes, Sir Edmund Barton, and all the rest of them. O'Connor, huge amount of people to put our Constitution together so it was clear. Don't come the nonsense that you think this, you think that. I don't care what you think. I don't care what anyone thinks. If it's not in the Constitution, it's not granted, it's denied and remains with the people, unless it's specifically granted to the states. Local government was never granted to the states in the format that it is now. It's granted to the states, as I said. The parliaments of the colonies were local government. None of them were joined together. The Australasian Council came in and started directing them, and then it was all abolished on the 9th of July 1900. The Constitution said so. Clearly says so. Now, after that, where's local government come into it? It's the parliaments of the state. If you took the time to read the Red Book by Quick and Garron, they explain exactly what it is. The Commonwealth Parliament once set up, and it never has been, I've already given you the evidence of that, and I can prove it with documents. if you choose to charge me with insulting you or slander or anything else. No, I'm telling the truth about you, because you're lying about everything else. Whether it's your lies or somebody else's you're repeating, it's irrelevant. Check up on your information, because the Commonwealth Parliament is a subordinate parliament to the British Parliament. The state parliaments are subordinate parliament to the federal parliament or Commonwealth parliaments. Fact, read chapter 1. Read page 791, 701, 702, 703 and 704. It clearly lays it out. And it lays out the fact that you are all bound by the Colonial Laws Validity Act. But even if that wasn't so, it states there by Quick and Garran, even if that act had never been enacted, no colony of England could rise up and change the laws of England. So, did you change Magna Carta with the Parliament? No. Can you? No. Habeas corpus? No. In fact, in HCA 44 of 2010, Chief Justice French and the full bench of the High Court, including Susan Kiefel, who willfully and deliberately disobeyed that, said the 1688 Bill of Rights, habeas corpus and all imperial law is law in this country and must be obeyed. You understand that? You understand that? Now, let's go to your so-called local government. If it was lawful, and it's not, where is the authority over your land? An estate in fee simple. Where does that come from? Chalice real property. Fee Joe versus the Northern Territory. It was decided that native title does not wipe out fee simple. What is fee simple? It alienates your land from the Crown. Now, if you had legislative authority and taxing authority, and it's alienated from the only source of that authority, which is the Crown, you just lost it. Wake up to the fact that you cannot talk around intellectual ability. I am only one of the 27 million make up this country. There is a lot more like me that I've been teaching and are teaching others that are starting to wake up, that people like you are sitting there and dribbling absolute lies to the kids and the students that go before you. The supremacy of the Parliament. 676, an annotated one which you don't believe in, says the Parliament is not supreme, and the very essence of federation is that must not be so, or must be so. They're not supreme. The Parliament, like everyone else, is subject to the law and must abide by it. So they're not supreme. Page 791, the middle of the last paragraph on that page, it says, neither the federal nor the state parliament are sovereign bodies. They're simply legislatures with limited authority. If they attempt to pass a law in excess of that authority, a law is a nullity and affords no obedience. How do you like that? I quoted out of that red book because it's annotated or the interpretation by the people who wrote it. Why did they interpret it that way? Because they wanted the supreme, absolute and uncontrollable authority to remain with the people. Answer those questions, answer what I've said, and to me. Somebody said they asked you to go head to head with me on TV. Bring it on. Bring it on. I'll leave all the books behind. You see, I was gifted with a good memory by the person who's behind what I'm doing. It's not your business who it is, but you will find out. Everybody does. You have a lovely day, but stop your crap. Thank you.